Hello friends. Today in this video we will discuss about violence that occurred in Bengal after the election results were announced. In this video we will also discuss about how India's politics is getting criminalized year after year and what are the steps taken by the government and Supreme Court towards curtailing it. In this particular incident, 14 people were killed. In that 14 people, 2 were women who were killed. BJP claims that 7 of the victims were its supporters. TMC claims that 6 of the victims are its workers. And the rest 1 or 2 are claimed by Congress and other left parties. But whoever it is who has been involved in this violence should be punished and a strict investigation has to be conducted in this case. After the current Chief Minister of Bengal, Mamata Banerjee, took her oath and affirmation, she has said this statement that administration was run by Election Commission. I was not in charge. And indeed, it is true because during the period of election, till the government is set, that is, government takeovers the power, Election Commission will be in charge of the administration of that state or the country. But why are these kind of violence are getting reported again and again? Why is politics in India is criminalized? This is the trend of MPs with pending criminal cases in India. From 2004 to 2019, it has only been increased. In 2019, it stands at 43% of our MPs are having criminal cases. If we search for the reason why politics is getting criminalized, we will get to know that earlier politicians used to take help of criminals for money and muscle power. But when these criminals got to know that it's only money and muscle power that can make a political leader, they themselves started entering politics and it only increased year after year. And even the political parties are forced to select the candidates with criminal background because winnability of a candidate with criminal background increases threefolds in our country according to various reports. And this problem only multiplies when the people of the country is uneducated and poor, because uneducated people don't know how can they go against the muscle power, and when the population is poor, money can suppress their voice. But because of all of this, the consequence is lawbreakers will become lawmakers. And when that happens, we can't expect good quality law to be made. And the quality of debate and discussion in the House will get reduced. And the government will have no credibility when it is filled with criminals. And corruption increases because their motive will be to make money. And violence increases during elections, as we have seen in this case in Bengal and many other cases in past. And because of corruption, black money increases. Because of all of this, global image of India will be decreased. You may ask what will happen if the image is damaged. Many of India's infrastructure projects are funded by global organizations like World Bank and IMF and many other institutions. When our global image is damaged, these institutions will become reluctant in funding India's development. And let us see party-wise segregation of MPs with criminal records. BJP is having 116 out of 301 MPs with criminal records, that is 39%. In Congress, it is 29 out of 51, that is 57%. In Trinamool Congress, it's 9 out of 22, 41%. So no party is having clean hands. If you see even the regional parties and all the national parties, all of them are having candidates who are having criminal records. Is there any law related to this? In Representative of People Act 1951, under the Section 8 of the law, an individual punished with a jail term of more than 2 years cannot stand in an election for 6 years after the jail term has ended. But those who are facing trial, no matter how serious the charge is, are free to contest elections. And in this regard, our Supreme Court has been very progressive and had given some of the very good judgments. Like in Association of Democratic Reforms versus Union of India 2002 case, Supreme Court has held that right to know antecedent or the criminal past of an candidate is a fundamental right under Article 19 of our Constitution. And in People's Union of Civil Liberties versus Union of India 2003 case, It has held that not just criminal past but the relevant information of the candidate apart from criminal records are also to be known by the voters. Those information might be bank balance, his family members and their bank balance and the total asset of their family. In a landmark Lily Thomas versus Union of India 2013 case, it has been held that the MLAs or MPs who are convicted for jail term of 2 years or more than it will lose their seat in the legislature immediately. What used to happen in Representative of People Act 1951 was that if a legislator is convicted, he used to get 3 month time to get an appeal to the higher court, and this used to take a lot of time. So in this judgment it has been made that the legislator will immediately lose his seat. In People's Union of Civil Liberty versus Union of India 2013, nota was introduced. If a voter feels that all the candidates are having criminal backgrounds and he don't want to vote anyone, he can opt this option. Though nota as of now don't have a spine, we can expect that this concept of nota will grow in a progressive way in coming future. And in the recent case of Public Interest Foundation versus Union of India 2020, not just the candidate but the political parties also must publish criminal antecedent of contesting candidate along with the reason, and that reason cannot be winnability of the candidate. And it is said in the judgment that they have to disclose what are the crime that the candidate is accused of, how many cases are on him, what kind of cases are on him, and the case details like case number, name of the court, and at what stage the case is, like if it is in the stage of FIR or investigation is going on or charge sheet has been filed or trial is going on. And the reason has to be mentioned, and where all of this has to be mentioned in the party's website and the social media platforms, which usually won't happen, and in one local vernacular and one national newspaper. Recently, Election Commission has come up with the guidelines saying that every candidate must declare their criminal antecedents 3 times before an election in a national daily and 2 regional language newspaper. From this, the public attention will be captured and greater awareness will be spread. And who will make sure that all of this is being done? Yes, it is our Election Commission. The political party concerned shall submit a report to Election Commission within 72 hours of the selection of their candidate. If they fail to do so, then Election Commission will notify the Supreme Court about this, and Supreme Court will consider it as contempt of court as the Supreme Court order has been breached. But the drawbacks of it is that average duration to conclude a criminal case in India is 15 years. Just imagine that person can win 3 elections during his case is proceeding. And the rate of conviction is also very low, that is 40 to 45%, which means more than 50% of the people will be acquitted. So it becomes our responsibility to know about the candidate before voting. That is, it is our responsibility to become an informed voter to create better India. Thank you for watching. If you feel the video was informative, please do like the video and subscribe to our channel.